The Espionage Act of 1917 is a United States federal law passed on June 15, 1917, shortly after the U.S. entry into World War I. It has been amended numerous times over the years. It was originally found in Title 50 of the U.S. Code but is now found under Title 18, Crime. Specifically, it is 18 U.S.C. ch. 37. It was intended to prohibit interference with military operations or recruitment, to prevent insubordination in the military, and to prevent the support of U.S. enemies during wartime. In 1919, the U.S. Supreme Court unanimously ruled through Schenck v. United States that the act did not violate the freedom of speech of those convicted under its provisions. The constitutionality of the law, its relationship to free speech, and the meaning of its language have been contested in court ever since. Among those charged with offenses under the act are German-American Socialist Congressman and newspaper editor Victor Berger, four-time Socialist Party of America candidate Eugene V. Debs, who languished almost 3 years in penitentiary after his conviction, former Watchtower Bible and Tract Society president Joseph Franklin Rutherford, communists Julius and Ethel Rosenberg, Pentagon Papers whistleblower Daniel Ellsberg, Cablegate whistleblower Chelsea Manning, and NSA contractor and whistleblower Edward Snowden. Rutherford's conviction was overturned on appeal, although the most controversial sections of the Act, a set of amendments commonly called the Sedition Act of 1918, were repealed on March 3, 1921. The original Espionage Act was left intact. Enactment. The Espionage Act of 1917 was passed, along with the Trading with the Enemy Act, just after the United States entered World War I in April 1917. It was based on the Defense Secrets Act of 1911, especially the notions of obtaining or delivering information relating to national defense to a person who was not entitled to have it, itself based on an earlier British Official Secrets Act. The Espionage Act law imposed much stiffer penalties than the 1911 law, including the death penalty. President Woodrow Wilson in his December 7, 1915 State of the Union address asked Congress for the legislation. "There are citizens of the United States, I blush to admit, born under other flags but welcomed under our generous naturalization laws to the full freedom and opportunity of America, who have poured the poison of disloyalty into the very arteries of our national life, who have sought to bring the authority and good name of our government into contempt, to destroy our industries wherever they thought it effective for their vindictive purposes to strike at them, and to debase our politics to the uses of foreign intrigue. I urge you to enact such laws at the earliest possible moment and feel that in doing so I am urging you to do nothing less than save the honor and self-respect of the nation. Such creatures of passion, disloyalty, and anarchy must be crushed out. They are not many, but they are infinitely malignant, and the hand of our power should close over them at once. They have formed plots to destroy property. They have entered into conspiracies against the neutrality of the government. They have sought to pry into every confidential transaction of the government in order to serve interests alien to our own. It is possible to deal with these things very effectually. I need not suggest the terms in which they may be dealt with. Congress moved slowly, even after the U.S. broke diplomatic relations with Germany, when the Senate passed her version on February 20, 1916. The House did not vote before the then current session of Congress ended. After the declaration of war in April 1917, both houses debated versions of the Wilson administration's drafts that included press censorship. After weeks of intermittent debate, the Senate removed the censorship provision by a one-vote margin, voting 39 to 38. Wilson still insisted it was needed. Authority to exercise censorship over the press is absolutely necessary to the public safety. but signed the act without the censorship provisions on June 15, 1917, after Congress passed the act on the same day. Attorney General Thomas Watt Gregory supported passage of the act, but viewed it as a compromise. The president's congressional rivals were proposing to remove responsibility for monitoring pro-German activity, whether espionage or some form of disloyalty, from the Department of Justice to the War Department, and creating a form of courts-martial of doubtful constitutionality. The resulting act was far more aggressive and restrictive than they wanted, but it silenced citizens opposed to the war. Officials in the Justice Department who had little enthusiasm for the law nevertheless hoped that even without generating many prosecutions it would help quiet public calls for more government action against those thought to be insufficiently patriotic. Wilson was denied language in the act authorizing power to the executive branch for press censorship, but Congress did include a provision to block distribution of print materials through the post office. It made it a crime to convey information with intent to interfere with the operational success of the armed forces of the United States or to promote the success of its enemies. This was punishable by death or by imprisonment for not more than 30 years or both. To convey false reports or false statements with intent to interfere with the operational success of the military or naval forces of the United States or to promote the success of its enemies when the United States is at war. To cause or attempt to cause insubordination, disloyalty, mutiny, refusal of duty, in the military or naval forces of the United States, or to willfully obstruct the recruiting or enlistment service of the United States. This was punishable by a maximum fine of $10,000 or by imprisonment for not more than 20 years or both. The act also gave the Postmaster General authority to impound or to refuse to mail publications that he determined to be in violation of its prohibitions. The act also forbids the transfer of any naval vessel equipped for combat to any nation engaged in a conflict in which the United States is neutral. Seemingly uncontroversial when the act was passed, this later became a legal stumbling block for the administration of Franklin Delano Roosevelt, when he sought to provide military aid to Great Britain before the United States entered World War II. Amendments for the law was extended on May 16, 1918. By the Sedition Act of 1918, actually a set of amendments to the Espionage Act, which prohibited many forms of speech, including any disloyal, profane, scurrilous, or abusive language about the form of government of the United States, or the flag of the United States, or the uniform of the Army or Navy. Because the Sedition Act was an informal name, court cases were brought under the name of the Espionage Act. Whether the charges were based on the provisions of the Espionage Act or the provisions of the amendments known informally as the Sedition Act. On March 3, 1921, the Sedition Act amendments were repealed, but many provisions of the Espionage Act remain, codified under U.S.C. Title 18 Part 1, Chapter 37. In 1933, after signals intelligence expert Herbert Yardley published a popular book about breaking Japanese codes, the act was amended to prohibit the disclosure of foreign code or anything sent in code. The act was amended in 1940 to increase the penalties it imposed, and again in 1970. In the late 1940s, the U.S. Code was reorganized and much of Title 50 was moved to Title 18. The McCarran Internal Security Act added 18 U.S.C. 793 in 1950 and 18 U.S.C. 798 was added the same year. In 1961, Congressman Richard Poff succeeded after several attempts in removing language that restricted the Act's application to territory within the jurisdiction of the United States, on the high seas, and within the United States. 18 U.S.C. 791. He said the need for the Act to apply everywhere was prompted by the Scarbeck case, in which a State Department official was charged with yielding to blackmail threats in Poland. proposed amendments in 1989. Congressman James Traficant tried to amend 18 U.S.C. 794 to broaden the application of the death penalty. Senator Al Inspector proposed a comparable expansion of the use of the death penalty the same year. In 1994, Robert K. Dornan proposed the death penalty for the disclosure of a U.S. agent's identity.